So good morning everyone, and welcome to number 5 in the Serenity series, which is legal webinars that are serious about your success. Such an important and interesting topic. But first, a little about me, in case this is your first time with one of my webinars. I am Michelle Whitehead. I am a homeschooling mum with 3 kids who are pretty much bound to make an appearance sometime during the webinar, because I haven't had a single one yet where they haven't. I'm a solicitor, an Australian solicitor, and I'm also qualified as a mediator, which means I'm not the sort of lawyer who goes to court. I like to help people work things out in a nice, peaceful, friendly manner. And I'm also an entrepreneur, and that's the work that lights me up, because I absolutely love supporting small businesses and people like me who love to DIY things, and people who are creative and who care about their clients, and as a result they feel cut out from the traditional legal system, and it doesn't need to be that way. My aim and mission in life is to make the law something that we can really enjoy using, that it protects us in so many ways. Moving on, getting into it today, what we're going to be covering today is we're going to start with an introduction to trademarks, following my normal format of what, why and how. So we're going to look at what are trademarks and what is the difference between trademarks and patents and copyright. And we're also going to look at what can and can't be trademarked and what trademarks actually protect you from, what they're useful for. The next thing we're going to look at is why you might want a trademark. What does it do for you? What's the benefits for your business? And we're also going to look at why you might need to have, or why you might want to have a lawyer to help you, because it is totally possible to DIY trademarks, and I'm going to give you some information about that. And then finally, we're going to look at the how. And we're going to look at the 2 most important parts of the how. The first one is the due diligence searches, because they are absolutely the most essential part of how to get a trademark, and even just how to choose a business name. How there's something really important to have in mind when you're doing your branding, when you're building your business. Even if you have no intention of trademarking in the future, just getting that due diligence underhand and understanding what can and can't be trademarked is incredibly important. And then finally, we're going to do a really quick walkthrough of the process, including how much it costs to get a trademark. So what is a trademark? Section 17 of the Trademarks Act 1995 defines a trademark as, so this is Australian Commonwealth legislation, so it's Australia-wide. All over Australia, this is the definition of trademark. And the same definition has pretty much been adopted all over the world. So, but there may or may not be other elements involved, like some of these elements might be different. But at its base, a trademark is a sign that is used or intended to be used to distinguish goods or services that are dealt with or provided in the course of trade by a person from goods or services dealt with or provided by another person. So those 6 elements, you have to have all of them. Now, a sign can be all sorts of things. It can be a letter, a word, a name, a signature, a label, a ticket, an aspect of the packaging, a shape, a colour, a sound, or any combination of these. So it can be anything from your name, your business's or product's name, your logo, or it can be a slogan, something a catchphrase, or it can be even down to the design of your packaging, that sort of stuff, or the particular way in which you do business. Now, the next thing is, we're going to talk about this more down the track, but a trademark must be used or intended to be used, and we'll get to that a bit more later. And now the next thing we're talking about is to distinguish goods or services, and this is the whole part of a trademark, and this is where so many trademarks fall down. is that it must distinguish, it must show, it must label or mark your services or goods as different from someone else's goods or services. And the next point is that it must be dealt with in the course of trade. So you must be using it to trade those goods and services. And it must be distinguished from other people who are trading their goods and services. So at its basic, a trademark is the sign you use to say, this is me, these are my goods, my services. It allows people who might want to buy your goods and services, or might want to buy the type of goods or services that you offer, to tell your goods and services apart from somebody else's, to know that this is, oh, that's Michelle, like my little castle up there that does. So as soon as you see it, it's supposed to be, boom, I know who that is. That's the essence of a trademark. And the reason I've got trademark and registered trademark down here is because registration provides a particular type of protection for a trademark, but trademarks themselves can exist just from use. So if you have all of these elements and you're using it constantly, you actually have a trademark. You just don't have a registered trademark. And we'll go into that a bit more detail soon too. So now we're going to look at the difference between a trademark, a copyright, and a patent. And the thing to notice here, I'm using Coke as an example because everyone knows about Coke as a trademark. Coke is probably one of the most famous, most litigated, most used trademarks in the world. So which parts, in this picture here I'm using because it demonstrates all three of these elements. So the trademark is obviously this Coca-Cola label, this color red, white on red writing, the shape of the letters. Any time you see it, you know exactly what that refers to. Coke have also tried to trademark the shape of their bottle. So that's another trademark. And Coke could also trademark this slogan here, open a Coke, open happiness. Right? So all of those things, they could be trademarked. They are all signs that are used to distinguish Coke's particular drink from any other drink being sold on the market. So that as soon as you see those signs, you know that's Coke. Now, copyright is designed to protect an original artistic or literary work. So, for example, the copyright here that we're looking at could be in this picture, this particular advertising picture with the ladybird and the sun and the happy, relaxed people. That would be copyright. Open a Coke, open happiness. If they weren't trademarking it, although you can see, if you look really closely, you can see just at the end here, open Coke, open happiness, it's got the trademark sign. So it's not a registered trademark, but they are claiming it as a trademark. And if you look down here on the Coca-Cola, you can see that it's got the little R for a registered trademark. But open Coke, open happiness, even if it wasn't trademarked, even if they hadn't used it often enough or intended to use it often enough for it to be a trademark, it would still be copyright because it's a published literary or artistic work. And I've talked more about copyright in one of my previous webinars. And if you want, I can put the link into the chat later when we do the questions. Just remind me, because I'll forget. Now, the third thing is patent. And a patent protects an invention. So the patent in this particular picture, Coke has a patent over the recipe for their soft drink. So here we have the trademarks that are designed to distinguish Coke from any other soft drink. We have the copyright, which exists in the intellectual work that Coke has put into designing their advertisement. And we have the patent, which protects their invention, which is the recipe, their secret herbs and spices, to use KFC's. Secret Herbs and Spices is a copyrighted, trademarked logo, but the actual Secret Herbs and Spices are patented. So just to sum that up, a trademark is a word, phrase, symbol, or other design that identifies and distinguishes the source of the goods of one party from those of others. So brand names, slogans, logos. Trademarks don't expire after a certain number of years. So trademarks last forever and for as long as you're using them. Okay, trademarks last as long as you are using them. Registered trademarks last as long as you're using them, so long as you continue to pay your renewal fee. And we'll talk about renewal fees and expiries at the end, but it's 10 years in Australia. So long as you pay your renewal fee every 10 years, your trademark can last forever. A patent is the right, a legally enforceable right to commercially exploit an invention for the life of a patent. So the patent gives you exclusive commercial rights. It gives you a monopoly over the right to sell that invention. A standard patent can last for 20 years. An innovation patent lasts for 8 years. And patents are really, really complicated. If you're going to get into patents, patents can only be dealt with by a patent attorney. You cannot DIY a patent. You have to go to a specialist patent attorney. But the thing I can say is that if you have an invention or an innovation that you think you might want to patent, don't tell anyone about it. Because the whole point about patents is that if you demonstrate it or sell it or discuss your invention in public before filing your patent application, you might not get it. A patent has to be something that has never been in the world before you've patented it. So if you do need to discuss it with your employees or your business partners or anyone else, you must sign a confidentiality agreement before you talk about your invention or your innovation. Once it's out in the world, it can no longer be patented. Okay, so moving on to business names. Registering a business, this is a common source of confusion. People think, oh, I've registered my business name so no one else can use it, and that's not the case. Registering a business name only gives you the right to use that name in business in Australia, to trade under that name. You do not own it, in the sense that you do not have the right to stop anyone else from using it. Now, it's unlikely that they'll register two business names that are the same, but even you've got no ownership rights. And similarly, registering a domain name does not automatically give you trademark rights. So if someone else has the trademark, they can force you to surrender your domain name. Using your business name and your domain name over a long period of time can generate common law trademark rights. Okay, so even though you haven't registered your trademark, and even though registering a business name or domain name doesn't give you trademark rights, the more you use it, the more you protect, the more it gets associated with you, the more you own the common law trademark. The problem is that a common law trademark is much more difficult to enforce and much more expensive to enforce than a registered trademark. A registered trademark is much easier, and there are much more remedies available to you. So there are specific remedies in the legislation that allow you to enforce your right to exclusive use of a registered trademark. A common law trademark, you have to get into the whole common law passing off and misrepresentation and fraud, and you bring in all of the surrounding circumstances as evidence to argue that this other person is using your trademark because they're trying to pass themselves off to pretend that their goods or services come from you. It's much harder to argue. A registered one, is much easier. So how do you choose a good trademark? Well, the most important thing, and we'll talk about that when we talk about due diligence, is to make sure it's something that no one else is going to get confused by. Now, I have popped up, I've actually found this amazing chart from 1950, and it shows you how trademarks haven't changed over time, and it's actually really quite useful in testing how good your trademark is legally. So in addition to choosing a mark that's not likely to be confused with any pre-existing marks, which means doing your due diligence searching, which we're going to talk about, it is in your best interest to select a mark that is considered strong in a legal or trademark sense. That is a mark that will most easily allow you to stop someone else using your mark. Some marks are much easier to protect than others, and these are considered to be strong marks. A weak mark is one that's most likely to be descriptive and that others are already using it to describe their goods and services. And this will make it difficult and costly to try and police it and protect it. So weak marks should really be avoided because they just do not have the same legal protection of a strong and distinctive mark. So we can see here that a strong mark, we're going to talk about these: arbitrary and suggestive, distinctive, descriptive, prohibited, all of those. But you might want to come back and look at this later and go through it all. I won't go through it all now because we'll run out of time, but it really is quite a useful thing. Some of the things to notice is that you can't register a trademark that is a geographical name. So Sydney lawyers cannot be registered. Newcastle Legal, that I work for at times, cannot be registered as a trademark because every solicitor in Newcastle has the right to call themselves a Newcastle legal person. Also, the thing here, no one can claim any exclusive right to a colour. V just tried that. You know, the V, the green that V uses, they've just tried to trademark that and they were refused the right. So that's interesting. So here's the difference between strong and weak. The strongest and most easily protectable types of marks are fanciful marks and arbitrary marks because they are inherently distinctive. So like my little castle up there, no one else is going to come and want to come along, and no other lawyer is going to want to use that mark. It's just so fanciful and distinctive. It's completely original and unique. Generally, marks fall into one of four categories: fanciful, arbitrary, suggestive, descriptive. Fanciful or arbitrary, so they're generally joined together. Suggestive, descriptive, or generic. And the strongest and most easily protectable, as I said, are fanciful and arbitrary. Fanciful marks are generally invented words with no dictionary or other known meaning. So Adidas, for example. Arbitrary marks are actual words with a known meaning, but that have no association or relationship with the goods protected. Now, I would have called Starbucks a fanciful mark because I can't think what its known meaning would be. In that arbitrary section, I would actually have put Apple. Apple's a perfect example of an arbitrary mark because the Apple computers, there's no actual association or relationship between an Apple and a computer, and yet Apple Computers works as an arbitrary brand. Does that make sense? Am I going too fast, or have you got any questions so far? I'll keep talking in case anyone's typing. So, fanciful, completely made up. Arbitrary, a total misnomer. It's like selling a brand of tyres with the brand name Banana or such. Now, suggestive marks suggest but do not describe a quality or connection to the goods or services. So suggestive marks are also considered strong marks. So if you're not going to go for a fanciful or an arbitrary mark, then a suggestive mark is your next best option. So, for example, glance a day for a calendar, chicken of the sea for a fish, quick and neat for a pie crust. The next one is descriptive ones. Descriptive marks are words or designs such as a depiction of a television for a television repair service. They're things that describe the goods or services. These marks are generally considered weaker and are much more difficult to protect. So butterfly courage, Renee says, I have butterfly courage for counselling. What would that fall into? So butterfly would be arbitrary and courage would be suggestive, or even possibly descriptive. But I think butterfly courage would be quite a good one. I think that would fall in the arbitrary suggestive range. If you called it something like counselling for courage, that would be descriptive and would head into the weak one. If you called it, I don't know, it's hard to think of them off the top of your head, but yes, definitely the butterfly courage, it's either arbitrary or suggestive, it's coming there. I mean, the butterfly isn't quite arbitrary, it's more into suggestive in the same way that chicken of the sea is, because butterflies have that sort of transformational suggestion to them. But definitely it's quite a strong, it's towards the stronger side. Descriptive ones we've gone over. So they're more difficult to protect because in order to register a descriptive mark, such as Oat Nut brand cereal or Newcastle Legal or so Renee says she has 3 names: Renee McDonald for her books, Heart and Soul Movement for her retreats and workshops, and Butterfly Courage for counselling. Butterfly Courage is easy to, it's probably likely to be easy to trademark unless someone else has already gone through that Butterfly Courage, has made that butterfly association or that courage association. And in that case, it would also depend on the totality of the mark, including your graphics. Heart and Soul Movement, once again, that comes into the suggestive descriptive range. So it's going to depend on how you have presented it in a graphic format. You would need to make it as a composite mark more likely, and it would depend on who else, if anyone else has used that section. And using your own name is the best, but you can't actually trademark a name because there are other Renee McDonalds out there who may want to use the name Renee McDonald's. For example, there's MichelleWhitehead.com. If you go to MichelleWhitehead.com, you'll find it's a photographer. MichelleWhitehead.com.au is me. So I can't trademark MichelleWhitehead.com. I can't trademark Michelle Whitehead, but I can trademark my logo and associate that with my name. And everyone has the right to use their own name in their business. So the way to get you can register your domain name, but as I said, domain names don't give you trademark protection. And you're really lucky if you can get the .com on your name because it gives you that worldwide presence. But if you're in Australia, then the .com.au is also a good way to establish yourself. So descriptive marks. Descriptive marks are considered weak until they have acquired distinctiveness. So you just acquire distinctiveness by wrapping it in a graphic package, which makes it visually distinctive, or by using it in a distinctive manner over a long period of time so that it becomes to be associated only with you. Now, for example, in this description, perhaps the distinctiveness is the typo. So Oat Nut Brand Cyril. So I don't think that it would really pass muster. I think you would have a huge amount of trouble registering a Oat Nut Brand Cyril or even Oat Nut Brand Cereal as a trademark, because it is just descriptive. People are going to the trademark examiner is going to say that anybody selling Oat Nut Brand Cereal has the right to describe their product as Oat Nut Brand Cereal. And it's heading into generic. So generic is really obvious. If you tried to trademark Apple and you were selling apples, you wouldn't get there. It's just the product name. If you tried, you could not trademark the name Courage Coaching or just coaching, because it is a generic name that every coach has the right to use. So moving on from there, yeah, it's really important. Lots of people have to go through rebranding just to make sure that their branding is distinct, and this is what everyone should bear in mind when they're choosing their brands. The benefits of trademarking. So I personally, to be completely honest with you, I do not have a trademark over my logo as yet. I will in the future, but right now I'm still in a startup phase of establishing my own business, and I am happy that my logo is distinctive enough for me to use it and use it and use it without running the risk that anyone else is going to encroach upon it. And at this stage, I'm not ready to take that step into trademarking. The times when you want to have a trademark are where you have a great slogan that is really catchy and you want to keep it for yourself. For example, an American lawyer has trademarked "Get all your legal ducks in a row." I have a friend, Ilka Oster, who is a faster EFT practitioner, and her slogan is "Keep tapping, create miracles." And I've suggested to her that that would be a really good one to trademark, because she says it all the time. It's associated with her. It's something that's catchy and memorable, and other people might want to use it, and she should want to keep it for herself. So it's an important part of the intellectual property of her business. Another time when you might want to have a trademark is where you have invested a lot of time and effort and passion in building your brand, and you're getting really big and well known, and you feel that need to be protected against knockoffs and people pretending to be you and fooling your audience into buying a cheaper or lower quality product from them instead of coming to you. And there's plenty of examples of those around. So the example that immediately popped into my mind was one of my clients, and I don't have specific permission from her to mention it, so I'm not sure whether that's a great one to mention. But yeah, when you've gotten to a stage where you want to be known for what you do, Leonie Dawson would probably be a good one. Any of the, Denise Duffield Thomas with Lucky Bee, all of those types of people may be ready or may have trademarks because they're known and they're out there, and people want to protect the exclusivity of their product against anyone else pretending or riding on their coattails. The next one is from a mindset perspective, and this is probably the most likely reason why I will get a trademark in the near future, is Just like getting a business bank account and your contracts or your client agreements into place, once you've reached a particular plateau of success, then trademarking your business name and logo can really help you to level up mentally. It can help you understand just how far you've come in taking your work from a hobby to a business, and that now it's time for you to progress fully and take that step over that threshold from amateur to professional. And having your own trademark can really, really boost that feeling for you. The next one is where you plan to build up a business that you can sell to someone else. And whether that's selling the business outright or franchising or licensing, as soon as you're expanding in that way or building something that you can sell for someone else and the whole business becomes an asset, then trademarking, a registered trademark that has a significant trading history is going to be an important intellectual property asset that will be really, really vital in selling your business as an asset, or selling your licenses, or selling your franchises, or selling your affiliate. Having the registered trademark for your affiliates or your licensees or your franchises to use or as an asset of your business is going to be really important for you. Now, in most cases, small businesses cannot afford the type of litigation necessary to enforce a trademark. And I've had so many people say to me, why should I get a trademark when I can't afford to defend it? And the answer here is that having your name or logo or slogan trademarked gives you having a registered trademark gives you a much stronger position in negotiation or mediation. If you do get into a dispute, if you do find someone using your name, having a registered trademark or having put trademark thinking into your brand, even if you're not registering it from the start, so that you are building up a common law trademark all the time. The more unique your name and its graphical representation, the less likely you're ever going to need to defend it. So just putting the trademark thinking into place in your branding has an automatic protective element. And having a registered trademark also makes it more likely that when people are doing their own due diligence, when choosing a business name, they're more likely to become aware of your rights and to choose something else because they realize you've already got it trademarked. And that also provides a level of automatic deterrent. So even if you think, I'm never going to go to court about this, I can't afford it, there are good reasons for establishing your trademark at an early stage and then sticking with your trademark and building it, whether you register it or not. As I said earlier, registering your trademark, it's a lot. And if you don't have a registered trademark and you do end up in a situation where you need to go to court around it, it's a lot more difficult. I've just had a client who has a big business. They've got their business name is well known. They've been using it for 16 years. And someone else has just registered a business name that's almost identical. And they're in a panic. And because they don't have a registered trademark, they can't, they never registered it at the stage because it was a descriptive mark. So now they're in a rush to register the trademark because that gives them access to the legislation and the easier pathway through litigation than the common law protections are. So next, due diligence. What sort of searches do you need to do? The most common reason why registrations are refused is a likelihood of confusion between your mark and a mark that's already been registered by someone else. Now, IP Australia, who's the Australian Trademarking Authority, they will say Hi Dominique, lovely to see you. We're just getting into the due diligence. We've had a quick run through of what a trademark is and how it, how's the best way to protect it. And really what we've looked at so far is really comes down to what you need to consider when you're building your brand, because building your brand creates a trademark whether you register it or not. So if you want to come back and look at the first half later, it might be a good idea just to clarify in your mind what you need to be aware of when building a brand. And now we're looking into due diligence and the actual process of getting a registered trademark. And I'm running out of time, so I'm going to have to race through it. So due diligence. The due diligence means doing your homework. And so IP Australia will determine that there is a likelihood of confusion when the marks are similar and the goods or services are related, so that consumers can mistakenly believe they come from the same source. So similar marks or related goods or services, each by itself, aren't going to support a finding of confusion, likelihood of confusion, unless a court has held that a mark is actually a famous mark. So generally, two identical marks can coexist so long as the goods and services are not related. So for example, my castle is my goods, my services are lawyers. If someone wanted to put that castle and they're selling candles, they could probably do it. I'd probably argue about it, but they could probably do it. So the first thing is each application is decided on its own facts, and there's no simple mechanical test used to determine whether a likelihood of confusion exists. And this is probably the most stressful part of trademarks, because even, I have to say, I had 2 trademarks that I'd put in for a client rejected yesterday. And even if you've done every search you can think of, there is still a possibility that something will pop up, or that the examiner will think 2 marks look similar when you don't think they're anything alike. But then you're back on the trying to prove that, or get permission from the other owner to let you do that, or redesigning your own. So doing this due diligence when you're at the branding stage and really getting in your own mind as clear as you can that there is no conflict anywhere is really important. So I'm going to just show you, I'm going to try going here. This is Atmos. This is the Atmos site. And I'm just going to resume share and change the page. I think that's what I need to do. New share. There we go. There we go. So this is Atmos. And Atmos is the Australian trademark online search system. When you come here, or you can find it really easily by Googling Atmos. Enter as a guest, and you type in here your words and images. So for example, I might type in business and Serenity, and I will do the search. And oops, why is my screen sharing paused? Resume share. It often does this. If you get this error, just refresh, continue. Yeah, okay, no search rep. I've done my due diligence on Business Serenity and no one's using it so far. That's another reason why I might go for trademarks, because I might want to protect Business Serenity before anyone else jumps in. Let's do another search. Let's do Renee's search. So go back to search. Let's search butterfly and courage. Search. And there's no matches. So that's great news. Let's search one that we will find a mark for, so you can see. So let's search courage counselling and see what we get. Nothing again. Okay, let's search. Let's just search courage and see what that brings up. Because that will bring up. Okay, so here we've got all of the trademarks that have been registered in Trademark. And now some of these have been removed or not removed. Were not removed. So what we can do here is refine our search down to pending and registered. Okay, so these are all of the trademarks that use the name Courage. And you can go through and you can look at them. And I suggest you do this. Even if you're doing Butterfly Courage, don't just say, oh, good, Butterfly Courage, there's no one there. Let's just do it. Go through all of the courage, go through all of the butterflies and can check them out, see, and you can refine it further here. See these numbers over here? These refer to classes, and I'll be talking about classes in the moment. But once you've determined what class you want to register, what class your goods and services in, you can enter your class number in here and refine, and then that will only bring up the ones that are in your class. So for example, so that's that site. I'm going to have to move on, but yeah, play around here at Atmos. Atmos is a fun place to play when you're doing your due diligence. The other places, so I'm just going to pause that, new share, and move to that one. Share screen, and then unpause, resume share. Got it. Okay, so the other places to go are to Google and Google Image. Do not, and also not just Google, but any search engine you know of, run it through your searches. Run it through every search you can think of. Check out Yellow Pages. Check out Bing and Yahoo and anything else. And also do a Google image search. Now, images are the biggest problem, and that's one of the trademarks I had rejected yesterday, was because even though we'd done all of our image searches and Google Images brought up no responses for it, there had actually been an image registered, and sometimes you just don't know until you get through the registration process that there is a similar image, and you need to be prepared for that possibility if you are registering a trademark. Now, the next thing to say is to use your mark. With trademarks, if you don't use it, you can lose it. A registered trademark becomes vulnerable to removal for non-use in Australia 5 years after the filing date of the application. So if you've registered your trademark, or if you want to register a trademark and it's being rejected because someone else has a similar trademark, and this is what I'm doing now with this one I did yesterday, if you can't find any evidence that they have actually used that trademark in Australia in the 5 years after registering it, then you can apply to have, so you get a 2-year grace period. So you can register a trademark if you're using it or intending to use it. And you've got 2 years in which you can start that using. Then 5 years after the date of your application, someone else can apply, has the right to apply to have it removed for non-use. And the period they look at is the 3 years before that non-use application, if this makes sense. So when you lodge your non-use application, the registration may be removed if the owner is not able to show that they have used the trademark in good faith in Australia in the preceding 3 years. Go on, go to the toilet. Sorry, a 4-year-old woke up. She wants me to go to the toilet with her. Hold her hand, but she's big enough to get there herself. So next thing, classes. Classes are the most complicated part of a trademark because you have to list, as we've seen, trademarks are only protective in relation to the goods or services for which they are actually registered. And the way to identify this is through what's known as classes. So you must list in your application the specific goods or services for which you want to register your mark. So the most common classes for my clients are, I'll just show you this. We'll go here. So I'll just pause that share, go to this site, new share. You can do it that way. Let me just find it on my, find it. I left it open. That's underneath it. There you go. Okay. Resume, new share. Where are we? There. Good. Okay. Resume share. Okay. So am I showing this one? There we go. Ooh, I've jumped forward on my slides too. Okay, so we're there, and we want to do a new share, and we want to share this one. Sorry, bear with me for just a second as I get this working. Okay, share screen. Okay, so here, this is IP Australia. And IP Australia try and be incredibly, incredibly helpful, because the law has decided that anyone should have the right to do a trademark. You shouldn't need to have a lawyer, although a lawyer can make the process easier for you and help you navigate the confusions and potential problems. So this is IP Australia. You can find them just by doing a Google search for IP Australia or Trademark Australia, and they'll pop up. So goods and services are divided into 45 classes. And they have here all of these videos. These are tiny little, really helpful, really useful videos. And really, if you have any interest in trademarking or questions about it, then jumping on here and watching some of these videos is a really good idea. But where we're going today is to the trademark classification search, which is where we can look at these goods and services. So you can, if it's something easy like footwear, you can just add your term in here. If it's more complicated, you might want to tick here. So these are goods, and here are classes 1 to 34. And they're all the different classes of goods that you might be interested in. The one that's most common for my clients to use here is class 16, and that ends up being used for, that ends up covering instructional and teaching material, including workbooks and manuals for business training courses. Also covers audio-visual, printed presentation materials, and audio-visual teaching materials, printed matters, books relating to business. Now, this is only if you are actually producing the books. So, for example, Leonie Dawson with her workbooks and planners would put them into class 16. Right. If you're writing a book about something else, then your trademark should go under the something else category. Not, if you're writing a book about counselling, then your trademark should be for counselling, not for books, because you're not in the business of producing books. Does that make sense? And I will duck up to services, because most of my clients go into services. So it's, yeah. If you watch the videos that I just pointed to before, they will explain this really, really clearly. They've got some great examples. It's really great. So classes of services. Services go from class 35 to 45, so there's less of them. For me, my main class would be class 45. But I might also want to do class 35, which is business management, business administration, marketing management, advisory services for businesses, production of video recordings for marketing, provision of information relating to business marketing, etc. That's a common one for my clients. Class 38 is another one, telecommunications. Now, if you click on class 38, it will give you this huge, huge, huge list of all the possible things that could be covered. And so this is where you need to sort of drill down to really work out. So it could be delivery of messages by electronic media and visual media. If you're providing video communication services, so not delivering a webinar, but helping people deliver webinars, you would want to be done in here. Even things like provision of hyperlinks to websites, it needs to be your main business. Trademarking fees are charged by class. So Oracle cards. Okay, well, let's search Oracle. Yes, Oracle cards would probably be class 16 because they are printed matter, but they would also be 40, which one is it? There's one in here that's spiritual, so let me just do spiritual. Search. Okay, spiritual, class 45. So Oracle cards, yes, you would do them in 16 because you're producing the Oracle cards, but you might also want to protect them in class 45 because spiritual guidance, mediation services, all of that sort of stuff, they would fit into this class 45 as well. So yeah, 16 and 45 would be the recommended classes for Oracle cards. So does that make sense? Has everyone got an overview of classes? Because classes are really, really complex, and we could spend all day just discussing classes, and we're already over 9 o'clock. So I'll just jump back to my slides now. If you've got any more questions about this, by all means, I'm happy to work through it with you at any stage. So jumping back, costs. I recommend for everybody, and I use it myself, the Head Start application process. So letter sounds in the background. It totally just threw me off track. Trademark Australia, IP Australia has a number of ways you can trademark. You can do your online trademark application. You can just do the straight out application, or you can do the Head Start process. The Head Start process is slightly more expensive, only a little bit. And I absolutely recommend it. And I will not do a trademark application myself without using the Head Start application for my clients, because the Head Start application is in stages, and it means that you lose less money up front if there's a problem. So when you do the Head Start application, you go through stage 1 where you submit your application and the examiner does a pre-assessment. They look at it, it costs you $200 per trademark per class. They look at it, they say, yeah, this will be fine, this will go through no troubles, and you can go through easily. Or they say, hey, look, we found this other trademark that it's too close to. And you then have 5 days after they notify you to work out what you're going to do about it. Whether you're going to risk it, go to stage 2 and proceed to examination, whether you're going to modify your trademark in some way. If it's a minor modification, you can do it within that pre-application process. If it's a major application, you've got to submit the pre-application again. So you've got to pay a new $200 per trademark per class. Okay, stage 2, you proceed to examination. The other things you can do is, there's no extensions on those 5 days, so you've just got to push through. Whatever you're going to do, you've got to make a decision in a fast. And there's a range of options, which I really don't have time to go into here today, but I will at some later stage, or you can ask me about them if necessary. Then you go to proceed to examination. You go to stage 2, which you pay another $130 per trademark per class, and that's where they really look at it rigorously. If they accept it, then it goes to stage 3, where they, IP Australia, publish the trademark and leave it open for objections. So anyone who doesn't want you to be able to register that trademark then has the opportunity to object to it, and you have the opportunity to answer those objections. If you get through the objection phase, your trademark is accepted. and then you register it, and there is no registration fee. Okay, so it's really $330 per trademark per class if you're doing it yourself through the Headmark application. If you want me to do it for you, I charge $660 per trademark per class for an easy one that goes straight through, or $880 if there comes up to be problems. Or actually, I tend to negotiate the prices. So $660 is my base rate. If you're doing more than one trademark, if you've got a trademark that's likely to have problems, come and talk to me and we'll work through and we'll agree on a price. If there are lots of problems, then it goes to a price per hour, because it's just impossible to estimate how complex it's going to be. But that's the basic one. So for $990, you can have one trademark in one class done by me, easy. And that includes all of your due diligence searches and everything else, as well as the application, correspondence with the trademark examiner. As I said, IP Australia, they've got all the videos, they've got all the information. You can do it yourself quite easily. It's just whether you're confident to go through it and whether you're willing to take the loss if it doesn't go right. You're risking that $200 of pre-assessment stage if you use the Head Start process. And it can be a useful thing to do. Like, you could discover that there's someone else who has a trademark, but they're not using it, and you could decide, okay, I'm going to just go and really work on establishing my trademark as a common law trademark, and then I'll come back in a couple of years, 3 or 4 or 5 years time, and then I'll register it once I've got that history of use, solid history of use behind me. So it's really strategic questions about costs. International trademarks. When you trademark in Australia, you are only protected for using your trademark in Australia. You can trademark internationally, but you have to trademark in every country that you want to protect your trademark in. So in the US, in China, in England, in Europe. And each one of these have their own trademark laws, and while there may be similarities, there are also differences and complexities. So given the global world these days, if you are looking at trademarking internationally, you should start by talking to an Australian lawyer with trademark experience who can advise you on which countries you might need, who can do some preliminary searching into what's required, and then to do the actual trademark application, go and get an international lawyer. Contact, there are services that do international trademarks for you, but it is expensive, yes. Expiry and renewal. Once you've got a trademark, it lasts for 10 years. I mean, when I say it's expensive, I may be exaggerating. I haven't personally looked into international trademarks beyond doing searches out of interest. I've never had a client come and ask me to do one. I believe there are services that will get you your US trademark quite easily, or will get you your overseas trademark quite in a streamlined way, because they are huge, massive online companies that do this, and they have a lot of leverage in those sense that they do thousands of them, and so they batch it a lot. No, it doesn't mean that you can't use the trademark working with overseas clients. Your trademark still works. It means that you can't stop anyone overseas from using, like, you can't stop an American from starting up a butterfly courage business unless you have trademarked butterfly courage in America. You can't. Does that make sense? You can be the only butterfly courage counsellor in Australia, but you can't stop anyone overseas using the same name. They could be the American butterfly courage counsellor. You can argue with it. You could definitely write to them and say, hey, look, I have this, whatever else. But yeah, you don't actually own the rights. Your property ownership in the trademark is only in the country in which it is registered. If you have been using butterfly courage consistently overseas, you might have those common law rights again. So you might be able to prevent an American setting up with your name, or an English person setting up with your name, or a European setting up with your name, if you can establish a strong history of your use in that area, in that other country. But then it would depend on the other country's common law trademark laws as to how it plays out. So yes, absolutely, you can practice in Australia and you can have people from overseas coming and signing up for you, but you cannot guarantee that you have the exclusive worldwide right to be the only person using that name or that mark. Okay? Right. Finishing up, trademarks in Australia last for 10 years. At the end of 10 years, you pay $400, you've got it again for another 10 years. And on and on and on for as long as you're using it. Trademarks last as long as you're using them. Common law trademarks last for as long as you're using them. Registered trademarks last as long as you're using them and you pay your application fee. The application fee may be subject to change over time, but this is the current one. It was just put in place on the 10th of October this year, so it's unlikely to change for quite a while. If anything comes up, if you have any questions, Friday is IP Day in my Facebook group, and you're always, always, always welcome to just jump in with a question. I've got an ask away policy, so ask away hashtag any day, ask a question, and we'll see if we can answer it for you. So I hope that really solidified your understanding of trademarks, and that you now have a much stronger idea about what to think about, how to make sure that you are choosing a strong brand and building a strong trademark, even if you're not registering your trademark. I'm not sure whether my video is going to work. Yeah, okay, there we are. So even if you're not registering your trademark, there's a lot of information in this webinar about how to choose a strong trademark and build a strong trademark and the advantages of doing that. Now, I have gone way over time, so I'm going to jump out there because my voice is dying and I'm really desperate for a cup of tea. And I have to jump onto Dominique's song healing call in a few seconds, so I'm going to stop the recording.